Okay, we're back at it with more thrilling and exciting PowerPoint voiceovers. We left off with court-like tribunals. I'm just going to really quickly show you what these are. When we say court-like tribunals, we mean like not formal judicial processes, but private processes like mediation. Mediation is a private, non-binding, voluntary procedure whereby people can try to resolve their dispute without taking it to actual court or without trial. Oftentimes, some court systems, like in California and elsewhere, will require parties try to mediate their dispute with a trained mediator before proceeding to trial. The idea is that if you can resolve it privately and voluntarily, don't bog down the court system. Mediation is usually a lot less expensive. It's non-binding. It's private. It can get things done pretty quickly. Arbitration is different than mediation. Arbitration is a binding process. It's a lot like a private quasi-court system. You probably have already agreed to arbitrate a lot of the disputes you might face, for example, with your cell phone company or your credit card company or even Westfield State, I'm not sure. But arbitration clauses have exploded in popularity and are in almost any kind of corporate service agreement or contract you sign. You agree to arbitrate any disputes. In the beginning, arbitration was thought to be faster and more efficient than going to court, but it's actually become very expensive, and oftentimes arbitration, because it's done before private boards, can benefit repeat players, meaning that if you're a credit card company and you have an arbitration clause in your contract, you are very familiar with the arbitrators and the arbitration boards and the rules, and you probably have quite a bit of sway over them. And oftentimes individuals who agree to arbitrate find themselves facing a tribunal that doesn't feel impartial sometimes, but also has very different rules about evidence and publicity and the kinds of damages you can get. It's really become quite a problem in society that arbitration has been co-opted to a large extent by kind of corporate entities. Anyway, let's move on. Why do we have courts? Well, they resolve disputes, right? Disputes between individuals, disputes between a person and the law. It's important. Most of the time, cases are resolved by settlement, meaning that the parties agree before trial to settle a case. When it's a civil case, it's by money. When it's a criminal case, it's by a plea deal usually. And then there are verdicts, which are rare. Almost all civil cases end in settlements before trial. Nobody wants to go to trial. Why? Because it's expensive and it's unpredictable. And even the biggest corporate clients usually don't want to risk taking a case to trial. Courts also modify behavior. By penalizing bad behavior and rewarding good behavior, courts shape the way we act, right? I mean, we don't go around behaving irrationally or behaving unreasonably because we know that there are repercussions for that. Courts allocate gains and losses. Courts can say, this party deserves to gain for this activity, and this party deserves to lose. Finally, courts make policy, usually not at the trial court level, but at appellate court levels, courts make policy. What policies do courts make? Well, courts can make policies about all kinds of things, like voting rights, like personal relationships, who you can marry, freedom of choice, your rights to carry arms, all kinds of things. So courts serve a lot of important purposes. Obviously, the trial courts dominate the first three of these purposes, right? Trial courts resolve disputes, they modify behavior, and they allocate gains and losses. But the appellate courts dominate the fourth. Most cases don't even get to the appellate courts. They end at the first level. Why? Because it's more expensive to go to appellate appeals, and you have to make all kinds of calculations about whether it's worth it. What is precedent? Precedent is when a court makes a ruling, usually at the appellate level, that is binding on lower courts. So the court makes a ruling on, the admissibility of evidence or whether or not certain activity is barred by some sort of law or the Constitution. Those rulings are binding on courts that are below the court that made the ruling. where do courts hold the least power? Maybe over foreign policy, but there are plenty of cases where courts exercise power over foreign policy, or exercise power over domestic policy that implicates foreign policy. Judge shopping. Judge shopping is where parties will look for a court that they think is going to be more favorable to them. Maybe that court is in a certain jurisdiction. Maybe that court has a certain judge. But parties who engage in judge shopping are looking for a more popular forum to hear their case. The environmental perspective discussed in the textbook, as you know from reading the textbook, has to do with the environment of the court and the environment of the area around the court. These things matter. If you're going to bring a case that that has a strong liberal bent, whether it's on same-sex marriage, something like that, you might bring that case in a certain environment where you think that the court and the local media and the local population might be more favorable to you. That's why oftentimes parties will, when parties have a big case to deal with, and we'll see this later on, they hunt around for the right place to bring that case. How are courts organized? You think they'd be all the same way, but that's not the case. Courts, depending on where they are, if they're state courts, they can be organized very differently. Things like where the court is. Is the court in an expensive area? Is the court in a non-expensive area? Is the court close to public transportation? Does the court have public parking? Does the court require filing fees, and what are they? And can they get waived? All kinds of decisions go into court design, courtroom layout. Is it a glass walls where people can see in the court? Are there guards, stationed in ways that are intimidating? One judge wanted to put up a picture of the Ten Commandments in his courtroom. Or is there a large cross? You can't have those kinds of displays in courtrooms because you're not supposed to have a decor or an environment that indicates some sort of potential bias. Who might be in a position to seek those advantages? Repeat players, people who are involved in politics locally. We have two distinct systems of courts in our country, the federal courts and the state courts. The first one is the state system. There are 50 plus separate court systems in the state courts. And then there's an entirely separate federal court system. They hear different kinds of cases. For example, in Massachusetts, we have a state attorney general, Maura Healey, who may or may not run for governor. And then we have a separate U.S. attorney for the District of Massachusetts. They are kind of different lawyers, different attorneys general overseeing different court systems within the same state or within the same area. State court systems are created by state constitutions. Those laws are set by state legislatures. What sorts of laws differ from state to state? The ability to buy fireworks, the ability to buy cannabis, the ability to, certain kinds of personal choices you want to make. All kinds of laws differ from state to state. A threshold question about courts and law is jurisdiction. Jurisdiction is a court's authority to hear a case. Does the court have jurisdiction? It really depends on a lot of factors. What the subject matter of the case is, where the parties are, who the parties are, what the applicable law is. State courts tend to assert jurisdiction over matters that occur within their state or to their citizens, whereas federal court jurisdiction is established in one of three ways, and this is really important to understand. Federal court jurisdiction, there are three ways to establish it. One is it a federal question? Meaning, is the dispute based on or applying federal law, like the Constitution or federal statutes? If it's a federal question case, it belongs in federal court. If it's a federal party, is a federal government or an officer thereof a party to the lawsuit? Those cases establish federal court jurisdiction. And finally, is there diversity of citizenship between the parties, and is the case worth more than $75,000? If both those things exist, then diversity jurisdiction is established and you can get into federal court. Those are the three ways that federal court jurisdiction is established. In the immigration ban litigation, ignore this because it was an earlier observation. But for example, in the immigration ban litigation, it was a federal question. There was also diversity jurisdiction, and there was also federal party jurisdiction. In President Biden's vaccine mandates, there's a federal question jurisdiction basis. There's probably also diversity jurisdiction, and there's federal party jurisdiction. So these grounds for getting to federal jurisdiction are not hard to meet, but you have them to get in. Jurisdiction can be exclusive or concurrent. I'm not going to bother with this. You can read it on your own. If you have questions, shoot me an email to the class and we'll go over it. But basically, it's in your textbook. And you've got to establish jurisdiction before the case can proceed. If a court can't hear the case, the court can't hear the case, and the case goes back to an appropriate forum. Some cases may only be brought in one jurisdiction. If it's a case based on a federal criminal statute, or if a case is valued at less than $75,000 and there's no federal question, you got to go state court. But some cases you can go to multiple courts. Why do you have diversity jurisdiction? Because state courts were afraid, or because people were afraid that state courts might privilege their own citizens. If you have a company that works in your state and they're being sued by an out-of-state contract or an out-of-state business partner, there was a fear that the state courts in the state where the company was located might favor that court, and that's why jurisdiction was established. With kind of modern media and with the modern jurisdictional environment, people are less worried about that. The trial court lobby might want to preserve diversity jurisdiction because you might get into federal court more easily, and federal courts have different reputations as far as the kinds of environments they provide for lawsuits. Forum shopping is the same thing as judge shopping. It's the same thing where you're looking for the right place to bring your case in the most positive forum. Sometimes in federal courts, you might think that the jury pool is different and the size of the damage awards may be bigger. Or maybe you like the evidence rules in federal courts better than state courts. Most cases go to state court because most cases are small. Most cases involve traffic violations, simple crimes. Someone didn't build the porch they were supposed to build. Someone didn't finish their painting job. All kinds of smaller cases. The vast majority of cases go to state court. The cases that make federal policy obviously go to federal court. Court structure. There are patterns that exist both vertically and horizontally. Vertically, the pattern starts at trial courts and goes to appellate courts. There's often 2 levels of appellate courts and then 2 Supreme Courts. It's a little confusing. In Massachusetts, the state Supreme Court is called the Supreme Judicial Court, or the SJC. In New York, there's an appellate court called the Supreme Court. There's all kinds of weird names in different jurisdictions. Then horizontally, oftentimes at the trial court level, you'll have cases divided by subject matter. You have housing court, for example, where a lot of landlord-tenant cases are heard. You have small claims court. You may have tax courts. You may have limited, civil cases like superior court or district court. You have divorce courts, all kinds of things. Family court. The issue of venue is where can a case be brought? Where do the parties reside? Where the matter giving rise to litigation take place? And if a party believes that the case is being brought in a venue that will be prejudicial to their client because of publicity, they might make a motion for a change of venue to bring their lawsuit in a different place where they think that people will be less prejudiced oftentimes by media or by the newspapers, whatever else. In federal court, you can bring all kinds of cases in the same place, and they can be consolidated into one big case. Oftentimes, that'll happen in, shareholder litigation, things like that. I'm going to stop here because we're out of time for this segment.